Hi, everyone. Thank you for joining our webinar, Florida Nursing Home Discharges. We have Toby Edelman here from Center for Medicare Advocacy. And later we'll to share the discussions, we have Maria Caruba Fuentes and Ellen Cheek from Bay Area Legal Services. Toby's gonna start us off though, and we have a lot of material to cover. So whenever you're ready, Toby, feel free to begin. Thank you.
All right, I'm ready. Thank you, Nicole. Next slide, please. So we want to talk about transfers and discharges now. And if you have any questions, please put them in the Q&A function. We will try to get to them or send them by email later. That will be fine too. Just want to make sure we all know which facilities we're talking about. Nursing facility is the generic term. The Medicare statute uses the term skilled nursing facility. Medicaid uses the term nursing facility. And if a facility participates in a federal payment program, meaning they're certified, they're shown on Care Compare, and they're the facilities we're talking about today. Next slide, please. So first, we just want to go through the legal authorities for transfer and discharge. Next slide, please. So there's, of course, the law, the Medicare and Medicaid statutes, respectively, both amending the creating the nursing home reform law as part of Medicare and Medicaid. Then there are the regulations. There's a single set of regulations for all facilities, skilled nursing facilities and nursing homes. And there's the preamble to the final regulations. The Obama administration decided to look at the regulations, which hadn't really been comprehensively reviewed in 25 years, and they came up with these regulations in October 2016, pretty much the same as they were before, but considerably reorganized. Next slide, please. The last authority is Appendix PP, and this is where CMS provides additional, very detailed guidance for surveyors. It's the official interpretation of the rules, but they're not as binding as the law and regulations, which went through notice and comment rulemaking. But this is where CMS tells surveyors how to conduct the survey, gives examples, it talks about scope and severity. It's a very, very lengthy document and keeps getting expanded. Next slide, please. Right now, the question is which version matters. There's an August 8th, 2024 version, which didn't make any changes in the transfer and discharge part from the 2017 version of Appendix PP. Then in November, CMS issued another guidance document, and that's been repeatedly, the effective date has been repeatedly delayed. So currently it's scheduled for implementation on April 28th. But my feeling is from seeing this morning that some other guidance document about ownership, facilities are required to resubmit validation data about ownership because there were new regulations, a whole comprehensive thing. A couple of weeks ago, they said, yes, the May 1st deadline, we're still going forward. Now I just saw they're not doing it. So my assumption is really that the November 2024 version will not be implemented just as a matter of, if you could call it, principle. So I do have a lot of slides about that version, but we won't really talk about them, I don't think, because it's not going to happen. Next slide, please. So as we know, there are 6 permissible reasons for evictions from nursing homes. Facility can't meet the resident's needs. The resident has improved and doesn't need the services provided by the facility. The health or safety of other people is endangered. Non-payment for the stay or facility no longer operating. Next slide, please. These permissible reasons are pretty much unchanged since the mid-1970s. We've had the same kinds of reasons for involuntary transfer and discharge, but there is more detail now in the regulations. And over time, I would say the rules and the guidance documents, Appendix PP, have become much more resident focused, really trying to make life better for residents. So one example is bed hold, which we'll talk about in a minute, which was originally an option for a facility. If it wanted to get paid for a resident who was in the hospital or on therapeutic leave, it could ask for reimbursement. Now it's the resident's right to request bed hold according to whatever the state pays. So I just have a couple of slides about the big changes in November 2024. The biggest thing is that they consolidated all of the F tags into two. Now we just have, or if this ever went into effect, one F tag, F627, about the basis for transfer and discharge. So was it done correctly? And F628 is the process. Did they do the process correctly? Big change in November 2024 was removal of the terms facility initiated discharge and resident initiated, and a tremendous reorganization and revision of the guidance information. Next slide, please. I think important changes when I looked at November 2024 Appendix PP is that the residence record must include documentation that supports the basis for transfer or discharge. Nursing homes can't just say in the discharge notice, we can't meet your needs, and that would be sufficient unless the residence record already included comprehensive documentation supporting the basis, it would not be valid. Very, very important. The second big change was a lot of discussion about discharges to unsafe locations. A number of us have been saying to CMS in various conversations, we want you to prohibit discharges to homeless shelters. And CMS was always very resistant in the calls we had with them, saying, no, that could be an appropriate discharge for some people. That's where they were before. That could work. We were pretty displeased with that. But they did say, and they say repeatedly in this 2024 guidance, that if the location to which the facility is trying to discharge the resident is not safe for that resident, then it can't go forward. That was important. And they also gave a lot more examples of immediate jeopardy and harm, really saying how, and those are the two highest levels of deficiency. Only about 5 or 6% of all deficiencies are ever cited as immediate jeopardy and harm. They're the only ones that are typically result in any kind of enforcement penalty. So here in 2024, in November, they expanded those examples. But as I said, I don't think that a collection of changes will go forward. But if it does go forward, if it does get implemented, there are a lot of slides at the end that you could look at to see what they say in detail. Okay, next slide, please. Nicole very kindly reviewed the state authorities to make sure that this PowerPoint was accurate. And she said she confirmed that they're still in effect. So that was really helpful, and I certainly appreciated that. So the basis for transfer and discharge, that is federal law, but the procedures for appealing a hearing decision vary by state. And Florida law seems to be pretty good about this. And they're in these sections that are cited on this slide. Next slide, please. So I want to talk about the August 2024 version of Appendix PP. And to the extent that I could figure out what happened in November and if they were also included, I put those November 2024 page citations as relevant in parentheses. So you'll see them, and I'll try to make that a little clearer as we go along. Next slide, please. So what they talk about in August 2024 is a facility-initiated transfer. And that means that the facility makes the decision about transfer and discharge. So it includes in August, if a resident leaves against medical advice when forced, pressured, or intimidated into leaving, that is facility-initiated transfer. The resident is really pushed into saying, oh, I'm going to leave, that is a facility initiated transfer. They also say if somebody's coverage is ending but still needs the nursing home level of care, that is a facility initiated discharge. This distinction, as I mentioned, is not included at all in the November 2024 revision. Next slide, please. If a resident, it's a resident-initiated transfer or discharge if the resident gives official written or oral notice of a decision to leave and it is documented in the resident's record, then that is a resident-initiated transfer. If a resident says, I just want to go home, or if a resident elopes, leaves the facility, that is not a resident-initiated transfer or discharge. Next slide, please. If a resident has a significant change that is not considered an emergency, then the facility must show that it did an assessment to determine whether it could revise the resident's care plan and still be able to meet the resident's needs. This is really good language that I unfortunately could not find in the November 2024 version. Next slide, please. So the regulations require documentation of the basis for transfer in the record, including why the facility can't meet the resident's needs, how it tried, and how a receiving facility could do what it somehow couldn't do, which is going to be difficult to say if it's another certified facility. Why is this new facility able to provide services that the discharging facility can't provide? Has to be documented in the medical record. Next slide, please. If the basis for eviction is that the resident's own welfare has improved or the resident no longer needs, so that the resident doesn't need the services that the facility provides, then the resident's own physician must have documented that basis in the medical record. If the basis for eviction is the safety or health of other people, then any physician is able to document that in the medical record. It does not have to be the resident's own physician. Next slide, please. The regulations themselves, so this is important, it's the regulations that say this, they require specific information about the resident to be sent to the receiving facility, contact information about the practitioner, the representative for the resident, any advance directive, and comprehensive care goals. That is required by the rules. Next slide, please. The rules also require that the facility give the resident a written notice of discharge, and the rules identify the information that the notice must include: the reason, proposed effective date, the location where the resident will be discharged, appeal rights, how to appeal, and how to contact the ombudsman for help. Next slide, please. If information in the notice changes, then the facility must update that information. And if it's a significant change, this is in Appendix PP from August. If it's a significant change, then the facility has to give a new 30-day advance notice. If it's a significant change in the basis or other reason for discharge. Next slide, please. So now I want to talk about non-payment cases. Next slide, please. A common issue is that Medicare is ending. But even if that's true, and I'll discuss that in a moment, the facility has to tell the resident that she can stay in the facility. She, of course, will need a source of payment, which could be private, out-of-pocket payments, or Medicaid. And if a resident is eligible for Medicaid, the facility has to help the resident apply for Medicaid. Okay, next slide, please. While the Medicaid application is pending, if it's been completed, the facility cannot discharge the resident. This protection is in the regulations and is discussed in the preamble. So that's an important citation at page 68,732 in the October 2016 final regulations. That's important information in the preamble. And it's also discussed in Appendix PP. Next slide, please. What CMS says very clearly is that a person going from private pay to Medicaid, which of course is a lower payment rate, is not non-payment. That is not non-payment. The facility can't say, now you're on Medicaid, we're going to kick you out. Can't do that. Next slide, please. When a resident appeals a discharge, appeals an eviction, the facility cannot transfer or discharge the resident during that appeal. Next slide, please. There's new language in the 2016 regulation that makes it very clear. This has been discussed in the appendix PP in earlier years, but 2016 final regulations made it very explicitly clear that no transfers or discharges can occur while the appeal is pending, unless, of course, there's always an unless the resident poses a danger to the health or safety of others as documented by the facility. Next slide, please. So Florida regulation, thank you, Nicole, confirms that if a resident requests a hearing within 10 days of receiving a discharge notice, the discharge is stayed pending the hearing. If the resident does not appeal within 10 days, the facility may discharge after 30 days from the date of the notice. Next slide, please. If there is immediate, this is the facility describes as immediate jeopardy, the highest level of deficiency, CMS describes this, a discharge while the resident is appealing. So CMS considers this a very serious matter, highest level of deficiency, immediate jeopardy. Next slide, please. Another big issue is what happens to residents who are hospitalized. In the past, nursing homes used hospitalization as a way of discharging people without giving any notice. They said, it's an emergency, you have to go to the hospital, and then suddenly they say, well, you can't come back. That was a very common thing to happen. We heard about this from a lot of people over the years, but there are changes now. So next slide. The regulations say that the residents have a right to have their bed held while they're in the hospital. This is in the regulatory language. The facility has to give the resident 2 notices of bed hold, usually before transfer, which often means in the admissions paperwork, there is language describing the bed hold policy. The second notice occurs at the time of transfer. When somebody goes to the hospital, they have to be told about the bed hold policy. Next slide, please. All information about bed hold has to be given to everybody, regardless of how they pay for their care, even if they're private pay or on Medicare. And this is confirmed in Appendix PP, both August and November, even though bed hold rights appear only in the Medicaid portion of the nursing home reform law, and Medicare does not ever pay to hold beds. Next slide, please. The facility must also provide information to the ombudsman, a copy of the notice of discharge at the same time that it provides the notice to the resident and the resident's representative. That's in both the August and November versions of Appendix PP. Next slide, please. The ombudsman can reach out and inform the resident of their options. And this notification of the ombudsman is also important so that the ombudsman, so that CMS can find out from the ombudsman what's going on and inform the survey agency when approached by the team leader before the survey, which is required. Team leaders are supposed to call the ombudsman program and say, what's going on? One of the specific concerns is transfer and discharge. Does the ombudsman have any examples of residents who have complained about transfer and discharge? So this is an important addition, giving this notice to the ombudsman, even though that might seem a little oppressive if there are a lot of them. Next slide, please. Florida bed hold policy says that the bed will be reserved for up to 15 days unless the state medically determines that the resident does not need to return or determines that the facility's occupancy rate is so low that there'll always be a bed anyway. Then it won't pay either. But Florida law does say that it will pay up to 15 days while a resident is gone. I always worried about that. Is that one of the ways they're going to save money? They'll say they don't want to reserve beds anymore. They don't want to pay. especially if somebody's in the hospital, somebody is paying for the hospital care, typically Medicare though, but they don't want to pay for two places at the same time for the same resident. But at least for now, Florida still pays for up to 15 days. Next slide, please. Bed reserve in Florida law is up to 30 days if the facility receives reimbursement. More Florida law. Next slide, please. Now, residents who are using Medicaid can be asked to pay for bed hold days that exceed the number of days paid by the state bed hold policy. So if Florida pays 15 days and the resident is still in the hospital, which would seem unlikely, the resident can be asked to pay for those additional days, use the resident's own income to pay to hold the bed. If a resident does not pay to hold a bed, then the resident can return to the next available bed, and that is a regulatory requirement. So that means it will stand, and it's also in both versions of Appendix PP. Next slide, please. Again, the regulation, residents can go from the hospital or if they're home visiting family for therapeutic leave to their previous bed, to their previous room if it still is available, and if it's not available, to the first available bed in a semi-private room. Next slide, please. Appendix PP, both versions, have strong language about the right to go back to the skilled nursing facility from the hospital while the resident appeals the discharge. So it's, they don't stay in the hospital. They go back to the nursing home, supposedly here, and what Appendix PP and the regulations say, and they appeal the discharge from the nursing home. So nursing homes can't just say you're in the hospital, can't come back. They have the right to go back almost always and then appeal from there. Next slide, please. This slide quotes the language of Appendix PP about the right to return pending appeal. Slightly different language in November, but basically the same point repeated. Next slide, please. Appendix PP says a facility cannot deny readmission to a resident from the hospital based on the condition of the resident when she went to the hospital. They have to look at the condition of the resident currently when the resident is ready to return. This is important because obviously they went to the hospital. There might have been a medical reason, a medical need that they couldn't have dealt with, but now they have to look at what is the condition of the resident who is ready to return. Important point. Next slide, please. The rule is clear that hospitals can't dump residents in the hospital and just refuse to readmit them. If it doesn't want to readmit the resident from the hospital, it becomes a transfer and discharge, and the facility has to comply with notice and hearing rights. There has to be a permissible reason for discharge. So CMS has tried in the regulations and in Appendix PP to prevent facilities from doing self-help and sending people to the hospital as a way of just discharging them without giving them notice. Next slide, please. The preamble to the 2016 regulation says that the state agency must provide for admission or readmission of a resident who wins a fair hearing. This seems to be a serious issue and a controversial issue in a lot of places where the state doesn't really enforce the fair hearing rights. But what CMS actually said in 2016 is the agency must, if appropriate, provide for admission or readmission of the individual to a facility. We need to try to enforce that, make that happen. Next slide, please. Florida law also says the resident must be readmitted to the first available bed in the facility, and the decision of the hearing officer is final. This is good Florida law, so we can rely on that. And it's the appeal goes to the District Court of Appeal, but it is the final administrative decision. Next slide, please. So discharge from Medicare is not the same as discharge from the facility. And this is a really, really important issue because what facilities say to people is, you're being discharged from Medicare. Well, discharge makes people think, I'm being discharged from the facility. I can't be in the facility anymore. But that's a different term. Whether Medicare pays is one issue, and whether people have to leave the facility is a different issue. Next slide, please. They're two separate issues with their own appeal rights. The notice of Medicare non-coverage is a notice that the facility must give to the resident if it thinks Medicare is no longer going to pay. And then people get to appeal that in the Medicare system. The separate issue is the nursing home discharge notice, and that's what we've been talking about now. Next slide, please. I wrote about this distinction in 2016 because we were getting a lot of calls from people who were told, being discharged from Medicare, now I have to leave the facility. So I wrote this alert. It's still valid. The regulatory citations have changed, but it's the same point. You can find the regulatory citations now in the 2016 October version, where they changed the numbering, but it's the same point. So if you have this issue of somebody being told Medicare is ending and people think they have to leave the facility, the answer is no. They have to have a way to pay for the facility, but they can appeal to Medicare whether Medicare will continue to pay for the resident's stay, and they also separately appeal the discharge in the Florida process. Next slide, please. Discharges to safe settings, not homeless shelters. Well, I mentioned that before. This is always a concern that we have, whether residents are being sent to a place that is safe for them. Next slide, please. Appendix PP calls it immediate jeopardy. So this is in November and August versions of the surveyor guidance, that if a facility discharges a resident based on the resident its inability to meet the resident's needs, and the resident had challenging behavior, this is their example of an immediate jeopardy deficiency, but other needs could be met and other residents had similar needs. So why can't they meet this person's needs? And the resident was discharged to the street, found by a passerby, needing immediate medical attention. Well, they sort of pile on all of the terrible facts, but in any event, CMS is recognizing that discharge during an appeal is one of those things that is not acceptable. Next slide, please. This is an issue we came to understand recently, is the importance of filing a complaint with the state agency. In Florida, the Agency for Healthcare Administration, AHCA, while requesting a fair hearing. And that's because a state agency will not cite a deficiency based on a hearing officer's decision. It must make its own determination of noncompliance as determined by a survey. So as we said before, the state must enforce the hearing decision, but it won't call it a deficiency unless there's been a complaint that it's investigated. Next slide, please. So what people need to do if they're appealing an involuntary discharge is also let the state survey agency know, appeal to AHCA, file a complaint, and let them know so that they can evaluate that and decide whether they're citing a deficiency for that noncompliance. Next slide, please. Nursing home closures. This is another permissible basis for involuntary discharge. Next slide, please. The rules say that the administrator of a skilled nursing facility that is closing must give residents and their representatives at least 60 days advance written notice, and they have to plan for the safe relocation of all the residents. 60 days advance notice. That's what the federal regulation says. But in the last few years, we've seen facilities close literally overnight. Largest facility in St. Louis closed overnight. People are moved out families see on the news that somehow there are these ambulances taking people, God knows where, very, very troubling to people. So we have strong regulatory language, but it does not seem to be enforced very well. Next slide, please. There's good language in the rules also about what the closure plan must say. That the residents are going to be transferred only to the most appropriate facility or other setting that provides, good quality, good services, that's an appropriate location, making sure that each resident's needs are taken into account. Sounds good on paper. It doesn't really happen in too many places. We've had number of facilities closed around the country without notice. Next slide, please. Florida law, also very good on closures. Facilities have to give at least 90 days notice, more than the 60 days under federal law, and a representative of the state must be placed in the facility 30 days before the closure in order to make sure that residents are fully protected. Good law. Be interested to hear people's experiences with that. Next slide, please. So this is where I started talking about Appendix PP. I think we don't want to talk about it. To the extent I could find the same pages, I did include them in the discussion of the August 2024 regulation, but I really don't think that this version is going to be implemented. I think they're likely. So you just keep moving through these slides. So you can say put in the red in italics. It's interesting. You can see when CMS makes changes in Appendix PP, it prints them in red italics. So you can see what they're adding. It's very clear. It's good. But they don't tell you what they're deleting. So that's hard to find. And I realized when I was trying to put the November 2024 page references into the earlier part about August, I couldn't always find them. And they were in very, very different places because of the total reorganization. But I think what we can pretty much rely on is what CMS did in August. So thank you. I don't want to take any more time because I know there's a lot to talk about today. But thank you very, very much.
Thank you, Toby. So that was a lot of great information, and these slides will be shared with everyone, all the registrants, that link to the recording, the slides, and then additional resources and materials will all be sent out tomorrow. So my name's Nicole LaRock. I'm with Florida Health Justice Project. I'm going to be switching gears a bit to talk specifically about nursing home discharge final orders here in Florida. So the Department of Children and Families, or DCF's Office of Appeal Hearings, is the agency that conducts the administrative fair hearings for these nursing home residents who are appealing the discharge action. The administrative hearing final orders are posted on the state of Florida's Division of Administrative Hearing, or DOA, website, and they can be found using the Florida Agency Indexed Orders search. This is the link for that. It can be a little tough to navigate without knowing exactly what you're looking for. So you would select the Department of Children and Families under the agency drop-down menu. And I have a screenshot on the next slide to kind of give some context. But for subject, it depends on the year you're looking for a final order. From 2015 to 2018, you would select Public Assistance Other. For 2019, kind of an anomaly, it was Public Assistance Medicaid is where they were housed. And then now, more appropriately, there's its own separate subject, nursing home discharge. So from 2020 to current, and they're up to date with the last filing being as of the end of February. And so hopefully they'll continue to update those. And then one can review, the reason that we bring this up is that one can review these orders. Advocates can glean a better understanding of the legal issues and advocacy strategies that can be used to help residents hopefully receive some better outcomes from appealing these discharge actions. So this is the screenshot that I mentioned with the two arrows pointing to what you would have to select to navigate to those final orders. And I myself conducted a review of some of these discharge hearing final orders from 2018 to the end of February of this year. I also received one from our friends at Bay Area Legal Services. And so I reviewed a total of 203 final orders. In those 203 orders, the resident's appeal was granted only 55 times, so a little bit over a quarter were successful in their appeal. The two most common reasons for discharge, with the first one being the resident has failed to pay for the stay at the facility. That was overwhelmingly the most common reason, with making up over half of those final orders. And then the second most common was that the safety of individuals in the facility was endangered due to the residents' status. And that was seen in about a quarter of those final orders. It is important to note, though, that nursing facilities will often select more than just one reason on the discharge notice for why they're discharging the resident, and that we saw that in 39 instances of these final orders. Another really important thing that we want to highlight is the representation that we're seeing in these fair hearings. So in the 203 of the 203 orders that I reviewed, 93 times the resident was representing pro se, and they only prevailed about a quarter of the time when there was pro se representation. And then following that, in 72 of the cases, they were represented by a family member, spouse, child, other family member. And in those cases, I actually saw a decline over the years, and only about 20% of the time did they prevail in those instances. Now, granted, there's a smaller sample size, but of the 203 orders, only 14 times were residents represented by an attorney. But of those 14 times, 57% of the time were they successful, which is a huge increase from what you would see in pro se or family representation. Interestingly, 7 times there was also someone from the ombudsman program representing the resident, and there was some good success rate in those situations as well, where out of this 7, 43% of the time the residents were successful in those appeals. So some factors I just want to highlight in successful hearings. A lot of the times there's issues with defective notices. Didn't see it as much in later final orders, but there were cases of residents sometimes not even receiving the notices, which I'm sure is occurring, but just not being captured in these final orders. And so that was something definitely the hearing officers were considering and would often lead to successful outcomes for the resident. The facility did not provide any supportive documentation or medical records as required under federal and state law, which is why it's so important to be aware of those requirements that Toby was highlighting earlier. The medical records were often not well documented or submitted either as required or to provide the evidence that would allow the facility to meet their burden. And then the facility often would at times even argued reasons that were not marked on the notice, but then that becomes a whole issue of whether or not the resident even had notice of what they were being discharged for. And then another common factor in these in successful hearings was when the facility did not provide evidence or testimony to support its claims. Very frequently, the hearing officers would indicate this, for the lawyers out there, that this was a hearsay issue when they didn't have that testimony to back up what was being claimed. So some other considerations I just wanted to highlight were that, hearings are based on these final orders, hearings are usually conducted telephonically, but residents may request an in-person meeting or hearing at the facility. residents can request a continuance, which is usually granted if they're still seeking representation, or they didn't receive the facility's evidence before the hearing, which seemed like a common occurrence. And then something that raises concerns for us, but is worth mentioning, is that currently hearing officers will only assess whether the reason for the discharge is lawful. This includes, if the notice is proper and the medical records are well documented, but they will not evaluate the adequacy of discharge planning or the safety of the discharge location. And they have this just standard, language that they use in almost every single one of the orders, mentioning this point. And they refer to ACA, which they refer the resident to ACA if they do have concerns with these issues, which is why it is also so important, as Toby mentioned, to consider filing a complaint. So now I'm going to turn it over to Maria and Ellen at Bay Area Legal Services to discuss what their experience has been like doing direct representation in these administrative discharge hearings. Thank you.
Thanks, Nicole.
Thank you.
One of the things I did want to point out is that in addition to everything else that Toby mentioned that's required to be put in the notice, the federal regulation also requires that for instances where you have a resident who's been diagnosed with a mental health disorder or a related disability, that the notice needs to include the mailing and email address of the agency responsible for the protection and advocacy of individuals with a mental disorder. And in Florida, that's Disability Rights Florida. And interestingly enough, we just, the final order that Nicole referenced that we provided to her, that was one of the deficiencies in the notice and was one of the reasons that we prevailed in setting aside the transfer and discharge notice. So that's an important feature. And the very interesting thing is that the Agency for Healthcare Administration is mandated to create the notice, but yet they have left out a space, because it's sort of if you've not seen the notices, it's a checkbox and a fill in the blank form, but there is no place to put in the space for Disability Rights Florida. But it doesn't matter that ACA didn't leave the space for it. The facility is required to include that, irrespective of the fact that the form doesn't have it, because that's what the administrator's argument to us was, well, it's not on the form. But that's just mistakes on two people's part. ACA didn't include it in their note. It hasn't included in their notice. And the facility is not reviewing the regulations as far as what they're required to put in these notices.
And the support for that is that Florida statute does provide that the facility has to follow state and federal law and regulation. So ACA's failure to put it on the form, that's a challenge for the facility, but that doesn't exempt them from compliance.
And basically, we've had the most success in representing individuals, and I'm shocked at how few cases where there was attorney representation, how shockingly low that is. But we have had a tremendous amount of success. I don't want to toot my own horn or jinx myself, but in every case where we've gotten involved, it's almost always been a defective notice, and we've been successful in every single case. So that's why it's important to, if you can, consider practicing in this space to help residents, because we're only finding a small percentage of them who are finding their way to us through referral system. The ombudsman, we have a relationship with them, but we know there are people who are falling through the cracks, either, like Nicole mentioned, are not even getting notices. And as Toby said, we've got robust regs and we've got robust statutes, but if no one is paying attention or realizes that the rules aren't being followed, and the average resident and their family members often don't know that, and the majority of our residents that we've represented have no one. So it's just them. They're already suffering from aging, mental health disorders, health issues. They just don't have the bandwidth to do it. And if the facility is not doing their job and making sure that they know what the safety net is, or the resident hasn't made contact yet with the long-term care ombudsman, oftentimes the rights are just not being communicated in the way that they should, and which are designed to protect this very vulnerable population. And the long-term care ombudsman, as Nicole pointed out, can actually represent residents at hearings. And we've often used the long-term care ombudsman as sort of a hand in the case, because on short deadline times when we can't get out to the facility to meet with the client, the long-term care ombudsman can go ahead and file the request for the fair hearing on the behalf of the resident. And that stays the proceeding, so the resident continues to reside until the outcome of the final hearing. Another point I thought about too was with what Nicole said about the hearing being in person, being mostly by telephone. So it tells you that it can be by telephone. Most of them are by telephone, but sometimes it's important to have it in person, because if your client has any sort of hearing disability, or just even diminished hearing, because you're sitting on a conference call with a hearing officer, the resident is on their own speakerphone or phone, the administrators and their witnesses appear, so the sounds can easily be muffled or not easily heard by someone who has any sort of hearing issues. And in one of our cases, having an in-person hearing, I think, was very important in our success in that case.
And don't assume when you make the decision, whether it's an in-person hearing or it's going to be a hearing by phone and you're going to be representing, we try to be there in person with our client, even for phone hearings. Don't assume that there's a nice, quiet, private space to conduct this. You have to make some advance arrangements. Most of our clients, for example, are in a double room. So having the hearing, even a telephone hearing from the room, is almost never a good option. And obviously having it in one of the spaces that's available to other residents is also not a good option. But most administrators we've dealt with, if we, give them some advance notice, will get us, allow us use of a room. We even sat, our last hearing was in, I think, the social worker's office, and while her phone ringing was a bit of a distraction, it was at least private and we could be present with our client. And there was, once we cleaned off her desk, there was a place where we could put our materials out so we could, go forward with the hearing.
And speaking of materials, when you get a notice based on a change in medical status, or that they can't meet the needs, it is crucial to examine those records, because that's another space where we have had a tremendous amount of success, because the facility really doesn't look at their own records. And the residents are often seen by a team of physicians or other medical professionals that are cycling through. They're seeing people very briefly. They're making a lot of times their notes are copied and pasted repeatedly, just repeating the same thing over and over again, are really not personalized. And that's another place where we invest the time to look deeply into the files, but it has produced a lot of really good results for us. So definitely request those records, because there's, often gold in there. In the last case we had success in, the facility was claiming that they couldn't care for our clients' needs any longer, but in their own records, I found a statement that said, that was put in, I think in, I don't know, maybe January of this year, saying that the conditions that the resident has were the same conditions that he came in with. Nothing had changed. So his needs had not changed. And it was right there in there. I mean, it was literally a smoking gun. So you really have to look at those records closely, and it is very helpful. And that's another place that the long-term care ombudsman can help facilitate, because they can access those records expeditiously any time of the day, and they can help facilitate that as well. It's been a tremendous partnership for us to have the long-term care ombudsman as a referral partner and providing us with assistance when we get into this space. So now I know we want to leave some opportunity for questions. Ellen and I do a lot of work in this area. We're working on a specific grant that really just allows us to focus on this work, in addition to some other issues that affect long-term care residents and also people receiving home and community-based services, which is a totally different topic. So if you want to reach out to us, please feel free to do that. We're more than willing to staff cases, and we strongly encourage people to get into this space, because you cannot get an any more vulnerable population who really their voice has not been heard nearly enough as it should be.
Thank you, Maria and Ellen. That was really helpful to get your insights on that. I want to thank all of our speakers today and everyone in attendance for joining us. I am going to share here just our contact information should you have any questions, want to reach out to us. And as I mentioned here, the recording slides and additional resources, some materials dealing with these issues will be available on our website tomorrow. I also want to take the opportunity, before looking to see if we have any questions, to share the CLE information. So that is 250-318-2N. And I'll repeat in a second, also include it in the chat here. 250-318-2N as in Nancy. So that included that in the chat. And let me just take a look here to see if we have any questions. So it
Nicole,
does.
could I just say something about what you said? That was very troubling to me, that the administrative law judges are not considering the location to which the person is being discharged. I think the federal rules are very clear about that, and the guidance is very clear that that is a serious component of a discharge. And it's not just discharges to homeless shelters and storage units and hotels. I mean, the more common thing is that they discharge somebody home or send them to an adult child's home. And certainly in the November guidance, they're very clear that there has to be documentation that the facility considered whether there was a caregiver to provide care to the resident after discharge, and if there was a caregiver, whether that caregiver was able and willing to provide care to the resident after discharge. So even if there's a legitimate basis for discharge, they can't just put people someplace and say they're not responsible. That seems like something we've got, all over the place, develop more fully, because the guidance is strong, and we need to make sure that the judges get that point.
And totally on point, Toby, because we had 2 nursing home transfer and discharge cases, 2 separate facilities. Both were being discharged to a homeless shelter and what Ellen and I further did was we did a little bit of recon. We spoke to the person who's running the shelter. They in no way could accommodate anyone with any sort of physical disabilities. They use bunk beds. It's just not an appropriate transfer. And so you are right. We do need to start enforcing that, because that is the method. That is where and this was 2 separate facilities that we had notices for. So it's happening every day, because they don't know they just want to get rid of people. And since the hospital route has now been cut off, they're coming up with more creative yet equally inappropriate discharge location. So we are seeing that a lot. So we'll continue to work on advocating in that space and figuring out how to navigate that with Nicole, and how we get these hearing officers to not draw this line in the sand, because clearly they shouldn't be.
The other point about that is the the documentation issue, the facility is supposed to have researched an appropriate discharge before giving the notice. In the last case Maria is referring to, in which the facility had proposed a discharge to a local homeless shelter, they had only begun to contact, the social workers had only begun to contact other facilities. I think it was 30 days after the date of the notice, which we also found
In the
their
notes.
in their progress notes. So we can't emphasize enough. Read those notes. They're tedious. You have to get the hang of the very bizarre cut, paste, repeat rhythm, but there are some nuggets in there. And that was very, it made an impression on the hearing officer, the fact that they didn't even start to inquire until 30 days after the date of the notice.
Yeah, thank you. Absolutely. It's definitely an area there's a lot more advocacy that needs to happen in this space. And it's great we're having this discussion and that so many people are obviously interested based on how many people we have attending. Going back to just questions, it doesn't look like there are any questions on the substance, just individuals asking how they can receive a copy of the PowerPoints, materials, and a recording. Those, as I mentioned, will all be on Florida Health Justice Project's website. I've included the link to that on in the chat. They will be updated tomorrow, and that link will also be sent out to everyone in email tomorrow as well. But other than that, I don't see any other questions. But as everyone's mentioned, feel free to reach out to us by email. You'll have our contact information. And I want to thank you all again for speaking, sharing the wealth of knowledge you have with all of us. And thank you all to those who attended.
Thank you, everyone.
Thanks so much.